Hi and welcome back to my channel. So today we'll look at professional ethics, what it's about. We'll look at the summary briefly, what it talks about. So professional ethics is simply the study of conduct for advocates. That's it. What advocates can do, what they can't do. Like how they are paid and how they are paid, how they represent clients. Are they to be blamed for, representing criminals or people who confess to them that they have indeed maybe committed the murders or the rapes or the corruption and all that. So knowing what an advocate knows about the accused person, are they to be blamed for going ahead to represent them? Why is an advocate excused? And why are the normal moral codes for morality that apply in our society? Why are they not applicable? Okay. To advocates? Is there a special standard of morality that is applicable to advocates that is not common to society? Is an advocate a bad person, for going ahead to represent people and defending them, when they are very sure that the a crime has been committed, that the person they're defending is actually, you know, evil in a way. To talk about that, we'll look at examples of the Elitse Masunaga case, where the advocates of Elitse, who had then killed her husband and then chopped him up into pieces and tried to throw the pieces of her husband in garbage bags and throw them in different places to try and get away with his murder, and then later pretending to his family that she hadn't seen him, you know. Uh, mm, so we'll look at the lawyers who represented, we'll take that example and look at the lawyers who represented Elite in her defense, okay, against the state, which was charging her for killing her husband for first-degree murder. So they will see that the advocates are really trying so very hard to prove to the court that Elite is not criminal, that there was no intention, there was no motive, it wasn't premeditated, that it happened out of fit of rage, that it was self-defense, that, all those scenarios. So they really went above and beyond to try and quash that charge for first degree murder. So we'll see whether those advocates are to be seen as evil people, especially when we know that Elise was found, that so much evidence was found linking Elise to uh, uh, to the murder, and then the mutilation of her dead husband's body, and it was alleged that the husband was still alive when she cut him up into pieces, and all that was because he was cheating with another girl. Okay, he was cheating. So we can see all these things. Were the lawyers evil for representing her, and not just representing but going above and beyond to insist she was innocent and to try and poke holes in the case of the prosecution. So professional ethics looks at the conduct of advocates in general, how they're supposed to treat their clients, how they're supposed to uh, treat the case of their client. Can they refuse to represent their client? We look at the cab rank rule and what it says that, like cabs, in New York City, anyone who walks to the cab is entitled to enter and just be taken wherever they want to go. So the same is to happen to lawyers or advocates who represent. If someone comes to them, they are obliged, if the matter falls within their competence and expertise, to represent. They can't say no, unless of course they will argue that perhaps they wouldn't do the case justice because they have so much other work that is pending, other cases, or they would say that it doesn't fall, the matter of the client does not fall within their expertise. So we look at several cases to deal with negligence of the advocates, and whether advocates can be sued by their clients when their clients feel like they haven't done their best to represent them. We look at uh, what factors determine the fees to be charged. Is there any standard fees? Like, is there any policy or any order that is supposed to provide for the fees of advocates, or can an advocate just charge whatever he wishes? We look at all this. So when you talk professional ethics, you talk about advocate-client relationship, how advocates handle clients, how clients complain against advocates, all these things. It's the dynamic of the business, and the reason why uh, the business of advocates is regulated is because it's a profession, and a profession, one of the characteristics of a profession is that it is regulated. There's a professional body that regulates. There's laws and acts that regulate. There are societies which regulate and try to control the business of the advocates, to try and control the environment, the client's interests, and the public interest, and the reputation of the profession. Yeah, so that is professional ethics in a nutshell. But we are going to look today at uh, we are going to look at the code of conduct and standards for advocates. That is SOPEC, and the relationship that it's the manner in which it regulates the relationship of client and advocates. We will look at advocates whether the money they give for their clients is in the same account as the ones they give for themselves and their office. We look at whether there is any standard of care that is supposed to be exercised by advocates in light of the fiduciary relationship between the advocate as an agent of the principal who is the client. We look at the duty of confidentiality, client care, and all those other standards. Okay. Yeah, so yeah, that is basically it. Mm, Uh, we look at the bodies which regulate the profession in Kenya, such as the Council of Legal Education, the Kenya School of Law, okay, the Law Society of Kenya. Will just all these are bodies which regulate or play a heavy role in the profession of advocates now in the legal profession. We'll look at the whatever. So the laws that govern um, professional ethics. We have the Advocates Act, being the act which deals with who qualifies as an advocate under Section 9, Section 13, academic qualifications, who practices as an advocate, all those things. It covers the disciplining of advocates and the complaints commission plus the advocates tribunal. The advocates, uh, what is it called? Disciplinary tribunal. The Council of Legal Education examines trainees who are to become advocates. It also regulates the admission of advocates into the to the uh, bar. I don't know what this means. Yeah, yes, the bar exams. I think where we have advocates and trainees who are given exams, and if they pass them, then they have complied with the requirements of being admitted. One of the requirements, another being pupillage, successful compliance with that. Um, Kenya School of Law, on the other hand, offers the diploma, the training for advocates, and uh, yeah, and then yeah. So passing the bar exam and pupillage entails the final uh, lap of the race to being admitted as an advocate, and these two institutions, Kenya School of Law as well as Council of Legal Education, regulating the admission of exams, the marking of exams, the training, advocate training program. Yeah. So, Law Society of Kenya is the professional body by which all these advocates are members. As long as you're admitted to the bar, you automatically you become their member. Also, the Law Society of Kenya issues practicing certificates to advocates and gives them, and you have to pay fees, annual fees, to renew your practicing license every year to this body. Okay. Also, what can I say else? Yeah. So basically, the life of a lawyer is regulated very heavily from beginning to end, because even as you have become a lawyer, you don't, you are not free from the regulation. Okay, you are still regulated because you then become a member of the Law Society of Kenya. Mm, okay, so there was a case of Kenneth Kiplagat versus the Law Society of Kenya, where the applicant filed an application challenging the Section 4 of Law Society of Kenya, which of course, as I told you, all advocates have to be members by virtue of the admission. the automatic members of LSK. So what Kenneth was trying to say was to challenge uh, that provision that an advocate is an automatic member, and because the Constitution of Kenya, um, of course, even right now has freedom of assembly, freedom of association. So not just the repealed one, even the current one, freedom of assembly and freedom of association. So what if he was arguing, what if somebody does not wish to be part of the Law Society of Kenya? That is Kenneth Kiplagat versus Law Society of Kenya. So the court held that, among other things, if the compulsory fees paid by a member of the Law Society of Kenya are not used for purposes which fall within the objects set out in the Act, then it is possible that the same can constitute an infringement of the member's rights under the Constitution to freedom of assembly. So the main justification of this is because that as I told you, you have to pay fees yearly to renew your license, and the only body in Kenya that can give you a practicing license is the Law Society of Kenya. You pay and then you are given their stamp. So that stamp you will use to do your business and conveyancing and all that. So what happens is that the fees, the justification for those fees is that they are being used for the welfare of the profession, okay, to uphold the objects of the Law Society of Kenya, which objects are the following. That is, number one, is to regulate the profession in Kenya, the legal profession. Let me just remind myself of them a little bit. Okay, so we have the objects of LSK, um, ensure that everyone who practices law has complied, okay, with the requirements of the profession. It ensures that uh, everyone who practices law meets the standards of learning and professional competence, that they set and maintain all the standards of conduct of advocates and professional competence, determine, maintain, and enhance standards of professional practice and conduct, facilitate realization of transform legal profession that is independent, efficient, and accountable, protect and promote interests of clients. Okay, so those are the objects of whatever this one of any another state of Kenya. So the monies will go there. That is what the court held. Now, Republic versus George Benedict Maina Kariuki, the law state of Kenya is primarily meant to regulate affairs and conduct of advocates in their practice and provision, and it has no power under its object clause to intervene in any proceedings before any court, whether or not the parties to those proceedings agree to its intervention. So the LSK mandate is limited; it cannot go beyond enforcing the object, and we have mentioned Aaron Kitonga Rengeria and others versus Paul Moite. The LSK, neither the LSK nor its members should engage in political discussions of the country. So advocates are not supposed to engage in political, but we have advocates who are um, in politics. So LSK should be an independent body. That is one of the objects. Okay, should be independent. Therefore, politics is going to make it biased. Okay, so accordingly, the extent to which LSK or its members are allowed to participate in the politics of the country is regulated. So argument, LSK has no role in the democratization process. So that is Aaron Gitonga Rengeria. We also have We also have Mohammed Ashraf, Sadiq, and another. LSK plays a major role in the discipline of the members of the legal profession who engage in professional misconduct, okay, and other offences. The LSK Secretariat hosts the Advocates Tribunal, Disciplinary Tribunal, so that should tell you that it plays a very key role in disciplining advocates for professional misconduct, okay. Mm. So those are the cases about the regulation. Now, let's look at so the society's view of the legal profession. This I remember. I remember that journal, which I made a video about it, the standard conception of a lawyer's role, which explained that a lawyer's role is divided into three. There is that neutrality, that they should not have any opinion against their clients or the accused people. They should also what was the other one? Partisanship. They should practice the principle of partisanship. That is, they should be loyal to their clients and represent them and their interests. And then there's another one which I forgot. Yeah. So that means that lawyers that journal explained that lawyers are not subject to the common morality standards of common society, but they are subjected to a professional code of conduct, and that is meant for the profession. For the nature of profession is that law advocates can find themselves in position where they have to defend the worst criminals, like I told you, like in the case of David Westerfield, David where Westerfield kidnapped, he kidnapped a girl. I don't remember her name. She was very young, so he kidnapped and killed her. I think he also assaulted her. So you can imagine the kind of situation, sorry, that is that the shock to the society, to the parents, and he denied it, of course, and his lawyers who were defending him knew that he actually had done it. So as long as there was no confession, it was left up to the prosecution, and it took many days before they finally found her body, her dead body dumped somewhere. And before then, but after the body was found, it was said that the lawyers uh, had almost wanted to enter into a plea bargain where he would have his life sentence reduced. Uh, uh, he would have his sentence reduced by confessing, where the body was and that he did it. So the fact that he that came out to society, everyone was shocked. Like, how could the lawyers have known this and have kept quiet? So the principles are just different. Lawyers are not supposed to be blamed for the work that they do, because everyone has a right to be represented, and also that is taking the principle of partisanship to the extreme, because you see these lawyers were just ready to they're ready to do anything for their client, even if it meant concealing such a horrible crime. And also, there's the other scenario where someone was a lawyer was representing the royal family in a suit. I don't know what it was called, and then because the lawyer was willing even to disclose things that would just devastate the whole nation, if they were found out, just for the interest of his client. So that is like taking the whole thing to the extreme. Mm, so the reason why I think lawyers have to be so unfeeling sometimes is because of the adversarial system uh, of courts in Kenya, where lawyers have to do their best, to represent their case, and whoever does their best becomes the winner of their case, you see, because the judge is not going to inquire or conduct investigations, or he will simply rely on the evidence given by the advocates from both sides. So the prosecution is put to its ultimate test, because if it doesn't conduct its investigations thoroughly, then there will be no enough evidence to convict, to convict these people, to convict the criminals. So, uh, yeah, so people don't like lawyers for that reason, because lawyers are, considered to be, indiscriminate or promiscuous as far as their representation is concerned. They represent even criminals and serial killers, and just name it. And they're supposed to keep an objective mind. Uh, okay, um, so the Advocate Act defines an advocate as someone whose name has been admitted on the roll of advocates, and that person uh, uh, that person has to have gone through under Section 13, has to have gone through the rigorous professional academic requirements, and for foreign advocates from the Commonwealth, or they have to be already advocates in their country, and to advocates of a superior court, and must have at least 5 years experience for them to be able to work here in Kenya, to be admitted. Also, there's the issue of whether an advocate is a qualified person if they act or execute documents without a current practicing certificate. This was held in the Anajwe Housing Limited versus National Bank of Kenya, which overturned the decision in the Loaya case, which had said that any documents of conveyance that were executed by an advocate without a current practicing license were null and void ab initio. So in the case of Anajwe Housing, the court held that no, the most important, what do you call, the as long as the person is an advocate in the meaning of the Advocates Act, that his name is currently on the roll of advocates. Whatever he signs, documents of conveyance, if he doesn't have a current practicing license, is valid. Those documents are valid, except now he can be prosecuted or charged with professional misconduct and disciplined, by the disciplinary tribunal. So we can see that, yeah. And then the court held in that case that the Advocates Act should harmonize who is a qualified person, because who is a qualified person to act as an advocate, because in various places they have mentioned academic qualifications, they have mentioned like in section 9 they have mentioned that he has enforcer practicing certificate, but in section which was section something, yeah, but in another section, I don't remember which one. Yeah, in section 2, the person is an advocate if they are whose name is entered on the roll of advocates. Okay, so you can see section 2, section 9, section 2, section 9. Section 9 says he has enforcer practicing certificate, so it's contradictory, and I think there'll be an amendment here. I don't know if there's already a amendment bill for this, but there should be one, because the case, the energy housing decision of the court, one of the orders was to harmonize who is an advocate in the Advocates Act between section 2, section 9, and I don't know which other section, which I forgot. Okay, so moving on, we have a case, Geoffrey Orao Obura versus Martha Karambu Kome. So Martha Kome is the Chief Justice, the current Chief Justice of Kenya. So there's a case here, Geoffrey Orao Obura versus Martha Kome. The court held that the provisions of section 9 are unambiguous and mandatory, and the principles of common law do not apply to the jurisdiction of the court of appeal is to be exercised in conformity with the Constitution and subject thereto to all other written laws. In those circumstances, the memorandum of appeal was incompetent, having been signed by an advocate who is not entitled to appear and conduct any matter. So you see here, this was a case about Geoffrey Orao, was a case about a memorandum of appeal which was executed by someone who was not, uh, who did not have a current practicing certificate, to held to be invalid. That is the case there. But so they have the case of Wilson Dolo I, but they don't know that this case was overturned by Anajua Housing. So in this document, the Ndolo I case was overturned. So there is no way it can stand. Then we have me, I'll just use the Anajua Housing case as the case for the who is qualified as an advocate. So Wilson Dolo I was also an advocate, where it was the advocate um, whose practicing certificate expired. Then he went ahead and executed a document. Belgo Holdings versus Ismail. The failure to have a current practicing certificate in place when practicing is therefore not considered a mistake by an advocate, which the client ought not to pay for. Give me advocate. So this was a case where orders of stay given by the court in favor of plaintiff were recalled because he didn't have a practicing license, practicing certificate when current practicing certificate when he appeared, without regard for the effect on the plaintiff. The court said that in such a manner, when offence is committed, or statute is breached, or contempt of court is committed, the law must take its full course, and the injured party will have to seek remedy against his advocate through other means. So I would say these ones, I don't know if this case would stand still, but if we have the case of Anajua Housing versus National Bank of Kenya, it would overturn the. Okay, excuse me. Now, precedence and seniority. We have the Attorney General being the chief advocate, senior counsel, the chairman of LSK, vice chairman of LSK. Senior counsel are those with 10 years and more experience, if I got it right. Sorry, 15 years. Yeah, they must have been advocates for 15 years and more. Yeah, so it's 15, not 10. There is also a different role of senior counsels. They are supposed to sign. Now, a senior counsel, uh, now advocate, okay, so senior counsels are not engaging one-on-one with clients because they receive instructions from other advocates and they are like the captains of other advocates, and they introduce other lawyers when they are appearing in the High Court and Court of Appeal. They lead other junior lawyers. Now, advocates as an officer of the court is to promote justice. So this is also the relationship of between an advocate and his role as an officer of the court. The advocate is supposed to be mindful of the law and the rule of law and promote justice. Every advocate and person otherwise entitled to act as an advocate shall be an officer of the court. So that is Section 55 Advocates Act. They have an ethical duty to tell judges the truth, including avoiding dishonesty. But then this would go hand and verse. It would fight against the what do you call the principle of partisanship as was entailed by Tim Dare, where I gave it several examples of those two cases where the lawyers went above and beyond to lie. They don't have the duty to disclose the client's information. Okay, advocate as a friend of the court, amicus curiae. So an advocate can address the court at any stage and in any matter to which he is not a party to help the court resolve the matter. The client's provision in Advocates Act. A client is under Section 2 is defined as any person who, as a principal or on behalf of another, or a trustee or personal representative or in any other capacity has power, express or implied, to retain and employ an advocate. Section 60A, 7 clients includes any person on whose behalf the person who gave the instructions was acting. So it can also include someone who's acting on behalf. Okay, that is that. So then we have creation of an advocate client. How is an advocate client relationship created? It may be made between a client and an advocate. When the client approaches the advocate for services and goes into an agreement, can be established by the advocate and the client agent. So it's not a must the client appears in person. Okay. may be created expressly or implied. Uh, so sometimes it can be implied you where you ask an advocate, to give you an opinion, for example, and they act for you, like they go and research and give you an opinion, even if you didn't sit down and calculate or decide on this fees. It's still an advocate's relationship. It may be created through retainer agreements or by employment. We'll look at what these retainer agreements are between an advocate and any person who pays the advocate's fees. So, um, uh, there is three types of the relationship that is created in advocate-client relationship. That is the contractual. This is where an advocate agrees to offer legal services. Okay, if you agree to offer legal services to the client through a contract, you say, I agree to uh, offer services through a contract. The contract can be expressed or implied depending on circumstance. So the contract can be expressed, or that is the first way we say the agreement way, can be expressed or implied. But even while it's implied, at some point it should be made express, where the advocate prints it out or puts it into words, into writing, and asks the client to sign. Okay. The ordinary principles of contract law apply, save that it factors in the fiduciary nature of the advocate-client relationship. And so the fees charged should be reasonable based on circumstances of the case and should be written and signed. This explains why advocate fees are subject to taxation before approval. So now, fiduciary is agent-principal relationship of trust. The advocate-client is fiduciary because of the trust the client has. The rules of professional uh, conduct and ethics therefore prescribe an advocate should behave, how he should behave under such circumstances. So the fiduciary is like you have more bargaining power. You are entrusted, excuse me, by the client's most confidential information, like the one I told you. The I think this is the of partisanship. It's called the principle of partisanship, where you are supposed to safeguard the interests of the client. Mm, so the rules of conduct prescribe how an advocate should behave under such circumstances. They should not disclose some information, certain communications which are regarded privileged. So, which regulator an advocate is supposed to handle the client's money and also to the best interest of the client. Rules on conflict of interest prohibit an advocate from engaging in conduct that is likely to create conflict of interest or conduct likely to embarrass the process of court. Agency relationship is the third type. An advocate is an agent or to his client, who is the principal. In all matters, he will receive the money payable to his client. If there's an award, the award will be paid into the advocate's account. If there is not advocate's account, but into the hands of the advocates who will uh, then transfer it to so he's an agent, meaning the client does not, the court does not deal with the client directly, but only through his agent, the advocate. So he will sign contract on his behalf. As an agent and advocate is expected to do all that the client would have done, whether with or without the authority of the client. An advocate is obligated to disclose all information which may affect client's judgment, whether he has asked for it or not. So you can see those three types of relationships: contractual, fiduciary, agency. Now, agency. Now, rights, obligations, and privileges of advocate. What are their duties? What are their duties? Okay. What are the duties? So we are told in Article 50, there is a provision for fair hearing of an accused person. The accused person is entitled to an advocate, and if he can't be uh, afford one, to have one appointed. There are a number of obligations which flow from advocate-client relationship, and they are obligations to client, obligations to uh, oneself, to third parties and other advocates, and to the court, and to the profession and the country. So all these obligations, they come, and it's interesting because we are talking about rights, but then it's more about obligations because given the nature of the profession, it's the the advocate is in such a position. If he did not exercise these obligations to court, to client, to profession, to society, to justice, rule of law, all that, he can do so much damage. That's why it's being squeezed, like a vice that is squeezing the soul out of an advocate, because from all these sides, the regulatory institutions, disciplining, complaints mechanism, all this, and then now all the standards of client care and conduct, and how to dispose of the matter diligently, timely, communicate, be confidential. All these things are put there so that to safeguard the nature of business. It's more like the advocate has been given a privileged role to play and forward the objects of the profession, but at the same time make his livelihood, but at the same time uh, do all that within strict supervision and codes of conduct, within strict obligations, so that they don't take advantage, because they could imagine if an advocate received what do you call, received the client's seal or stamp, received the title documents, original title of properties of the client, they could just as easily transfer it to them, and disappear, never to be seen. So it is very important that the advocates or the business of the advocate is supervised and disciplined, Yeah, so that is about it. That is what it's about. Now we see that now duties of an advocate to clients, it's the duty of being, representing them, doing your best, making sure it's expedited, you don't do any delays, obligations. Yeah, so the duty of course of confidentiality, you must maintain the secrets of clients. That is explains why the lawyers of what do we call the lawyers of David Westerfield refused to the lawyers of David Westerfield refused to the lawyers refused to disclose that they were about to enter into a plea bargain where David Westerfield would have said, he would have uh, confessed and told them where the body was in return for a lesser, maybe, what do you call, in return or commutation, like a lesser sentence or something. So that is basically it, and it is that, yeah, the duty to client is of paramount importance, of confidentiality, of diligence, representing their matter without any undue delay, of communication, honesty, good faith. Um, Then there is Section 137 of the Evidence Act, which says no one can be compelled to disclose any confidential communication which has taken place between him and his advocate unless he offers himself as a witness. Uh, uh, So then we have Section 134 Evidence Act. No advocate shall at any time be permitted, unless with client's express consent, to disclose communication made to him in the course of his employment as an advocate on behalf of his client, to state content and condition of any document which he has come to see or partake in the course of uh, his professional employment, or disclose any advice given by him to his clients in the course of such employment. So this privilege does not extend to communication made in the furtherance of any illegal act and to any fact observed by an advocate in the course of his employment. So you can see here that Section 134, 137 of the Evidence Act is holding the efforts down as far as confidentiality as a duty exists, because people, advocates deal with very sensitive issues. They deal with confessions by clients. A client would come up to them and tell them, you see, I've killed this, I've killed, I have raped, I have killed 100 people, uh, and and you are supposed to defend them, and you can only disclose that if your client consents that he's willing to make a confession, and let's be, but if he tells you all these details and then you kind of you know disclose that, or so that's why it's very hard. I mean, advocacy is a messy business because it will challenge your religious beliefs and everything. Because imagine if I was to be in a position where I am looking at this person whom I'm supposed to represent, he's my client, and he just told me that he raped and killed a 7-year-old girl, on her way from school. How am I even supposed to be? I don't know where I would start. Like, My beliefs do not allow me to condone such, to even defend, to utter even one single word in his defense. But you see, when it comes to this business of advocacy, it is what it is. Even in the case of Gabriel, in the case of, the trials of, what do you call it? The trials of Gabriel Fernandez. So you can see the parents of had still the parents had, what do you call, the parents had abused and beaten him to death, you see, bloody and everything, and all the it was seen, you see, all the tissues and tendons and you know the bones and the fractures. So there was an advocate, okay, who represented them during that case, and I'm sure they were not happy because that was a huge case. That was a case that opened up, you know, that was a case that put the whole children's services system, okay, under scrutiny, heavy scrutiny. Even social workers had served prison time due to that case, because they had overlooked the complaints which they kept receiving from Gabriel during that time, and Gabriel's teachers who would notice him come to school, come to class with black eyes, with all these kind of signs and of abuse. But they when they reported the children's services had so many reasons to say why they couldn't handle this case. Even a security guard at what was it, the social security center, I don't know. When he saw Gabriel, you know, he in the condition, he tried to report, and this is what happens. And shortly after he died, you know, no one did anything to protect him, to get him out of the house, out of his family's, environment, and he died. So that case is huge. There's a show on Netflix about it, the Gabriel Fernandez, the trials of Gabriel Fernandez. Now, in those trials, you will see that there's an advocate who represents the parents, the parents of Gabriel, and of course she had to, like play her part, and but you would see how conflicted obviously anyone would become in that situation. It's a child we're talking about. Some people would cry in the course they were taught to excuse themselves just by listening at the cruel treatment. Then there's this other case also of Adrian Jones back in 2016. The parents, one step, one birth parents, they tortured him to death, put nails into him, made him stand in cold swimming pools. Uh, they just tortured him like Nazi style torture, like inhumane. You would think he was some kind of, it was horrible. I cried that time when I found that in the news. So you can imagine uh, how much lawyers have to turn that humanity switch off in order to represent such horrible people in the world. Then we have serial killers, people like the raincoat killer in South Korea who got represented. He confessed to killing over 20 people, 20 people, and he wasn't even old. He was just a man, I think in his early 30s or something, and he killed so many women. He killed and burned and went into people's homes and hammered them down with this huge hammer, and killed them, the children indiscriminately, the whole family. So this person got represented by an advocate who was trying to secure his interests, but his client's interests by making sure the counts against him are reduced, so that from 21 it came to 20. So you can imagine, it's just I have no words to say. It's just the things that lawyers have to do, the advocates, the duty they have to their clients to protect their interests, to safeguard their secrets. Okay. So he should also, another duty to clients is honesty and good faith. Avoid situations giving rise to conflict of interest, keeping clients informed about progress. Honesty and good faith. Now, if the advocate fails to handle clients' matters honestly and with good faith, he he can be sued, both criminally. He can be prosecuted criminally and be sued. We have a case of Guicherry versus Republic. So in this case, we have the appellant, an advocate of High Court, was appealing against his conviction on the charges of 18 counts of theft by agent and had been sentenced to pay a fine of 50,000 on each count and serve 12 months imprisonment on each count. The appellant argued that the advocate's client barred the complainant from instituting criminal proceedings against him. The court, in dismissing his claim, stated the appellant in this case did not act as an advocate. He used the fact that he was an advocate as a cloak to put in place a scheme to defraud the estate of the deceased persons of what was rightly due to them. It is our finding that the advocate's client regime does not preclude the state from instituting criminal charges where it has been established that a criminal offense has been committed. So the advocate-client relationship does not bar criminal uh, prosecution. Okay, that is Guicherry versus Republic. These cases, I wish they would just, I think I will go through them again sometimes because they're highlighted already. Effective zealous representation, that is another duty. You must do your best, use your best skills, be competent, do the, you know, what do you call? Okay, you should be competent. If not competent and you proceed to represent a matter of seriousness, then you can be liable to a fine or even disbarment. Now, that is the effective duty, the duty of effective representation. The consequences are grave. Yeah, disbarment is serious. The aggrieved client can lodge a claim, okay, against an incompetent or negligent advocate. As such, ineffectiveness can have disastrous implications for both financial and time. If the advocate's incompetence concerns a case that is in court, the courts have tried to avoid visiting the mistakes of the advocates on the clients in the interest of ensuring justice is served. We have two cases. Murai versus Wainaina, the door of justice is not closed because a person of experience who ought to have known better has made a mistake. The court may not forgive or condone, but it ought certainly to do whatever is necessary to rectify it in the interests of justice. In the case of Gar versus Marmanet Forest Cooperative and Credit Society, the advocate for the applicant was late in serving a notice of appeal on the other party due to what he admitted was his own mistake. So this advocate in Gar versus Marmanet Forest Cooperative and Credit Society, he did not file the notice of appeal in time. He sought for the court to exercise its discretion and grant him an extension to serve. The application was allowed because the court found that there was no unnecessary hardship that would be visited on the other side. So you can see that mistakes on the part of advocates uh, can harm the case. Okay, they also have a duty to follow directions. So an advocate is engaged by a client to pursue his interests, and so an advocate should follow a client's instructions as opposed to making decisions for the client. So a client must follow the directions of the client. An advocate must follow directions of client. Um, Also now we are told he should do that sparingly, where without injuring other people and their profession. Okay, advocates should not accept instructions which would entail conduct that breaches code of ethics. Advocates who has control of matters before court should not be instructed on what to do and which defenses to plead, what evidence to tender. So yes, he needs to follow directions, but it's more like he needs to follow the wishes of the suggestions or wishes of the clients in his best interest, but the client cannot meddle in how he undertakes to give evidence, which evidence he can give, like that is professional business of the advocate. So that is the limitation here. Okay. He is also allowed to act without consent, like enter into settlement if he thinks it will benefit his client. Ostensible authority to compromise on behalf of clients. This authority must not be used in a manner as to oppose the instructions of client. Now, case Guicherry versus Republic. The appellant disputed the decision of his advocate to withdraw an appeal because the appellant had already served his sentence. In striking out the appeal, the court explained the settled legal position by quoting, "The client's consent is not needed for a matter which is within ordinary authority of counsel. Thus, if in court, in the absence of client, compromise or settlement is entered into by counsel whose authority has not been expressly limited, the client is bound." So, Republic versus District Land Registrar and another ex parte, Guicherry and another. Now, the consent was entered into by the applicant's advocate without any information being given to the applicant. Yet the essence of the consent was prejudicial to applicant as he was the subject of order. He was never informed of application for injunction of the order arising out of it. applicants sought judicial review of consent orders. In allowing the application, court held as follows: although an advocate has ostensible authority to compromise his client's case, employment of such authority cannot be upheld where counsel consents to orders which are so opposed to the express instructions of the client. So, yes, you need to follow, you can have some form of compromise, but you must make sure that was district land registrar, expert Guicherry, and another you would yeah, so you would be suspected of fraud or collusion with the opposite party, conflict of interest. So that is duties of advocates to the client. Yeah, then we have duties of advocates to public. Uh, Duties to the public include the things I have told you. What did I tell you? Uh, Duties of an advocate extend to other people as well and the public. The advocate is also part of the society. Okay. Obligation to prevent unnecessary harm to other people and the public. Okay. An advocate can, in this instance, refuse to take instructions if it's against the public interest, okay, if it will harm the public. So that is one of the excuses or scenarios where an advocate can say no in the Cabranc rule. They can say no in that case, in the case where the client's instructions prejudice the public interest, okay, the welfare of the public. Okay, yes, we move on. The responsibility to promote just and effective legal system. There should be justice, honesty, fairness, good faith, whatever. Obligation to help develop a wide range of appropriate dispute resolution. So you should not just push for institution of a case in a court when there is an opportunity for out of court settlement. Promote affordable and convenient access to justice. They should not charge exorbitant fees. But also, the advocate is not allowed to undercut. So you cannot charge less than what is in the order. That is an offense, yeah. Duties of an advocate to the opposite party. Rules of professional courtesy. Your fellow advocates. Mm. So, so where an advocate is taking over a matter from a previous advocate as a matter of courtesy, you are supposed to give them, you are supposed to notify the former advocates prior notice must be given to the advocates before you go ahead uh, and file a notice of change of advocates. Okay, so that is that. The duty to your fellow colleagues. Okay, the duty to your colleagues in the profession. You give them a notice, you write a letter and tell them that I intend to take over the matter uh, from you and represent the client in his case. You can ask for, if there are any documents, pending, if there's any, it's just professional courtesy. If there is any bill, when you change advocates, you must pay the other advocates instruction fees, even if they have not started working for the drafting pleadings for you working for. Okay, but if they have, they'll be also entitled to the fees in respect of the work they have done. So what else can I say? Mm, yeah, that is the duties of an advocate to the opposite party, uh, to the other advocate. You can't also be unfair or adverse. You can't also be unfair or play dirty, because you're both advocates. For instance, rules of professional conduct obligate an advocate not to hide any authority that may assist the adverse party in advancing their position. But this is, you see, contradictory, because if you were to tell the advocate, you may want to rely on Section 7, or you may want to rely on this case to beat my argument. It's kind of interesting, but really, I don't know how it's gonna work, but it's interesting for me. Hmm? Shelley Beach Hotel versus Kenya Revenue Authority. This is a case in order that judiciary may be respected as pure foundation of justice and the bar may be trusted as a trustee of clients' cause. They have to submit to some ethical regulations. There's an established code of conduct, written or unwritten, for regulating the behavior of a practicing lawyer towards his adversary in law. His behavior must not display any double dealing or the act of a trickster. An advocate should be frank, reasonable, and his attitude should be that of an ardent advocate for a cause, but not that of a personal enemy. So it should be frank, reasonable, and uh, your behavior must not display double dealing, or you should not mislead your opponent advocate. Shelley Beach Hotel versus Kenya Revenue. This is also a duty that the advocate owes by the court by virtue of being a trustworthy officer of the court who should stick to the truth in all situations. This is based upon the oath that the advocate takes during his admission. Therefore, the advocate will be held guilty of professional misconduct for intentionally hiding the truth. Okay, so duties. So if you make promises to your opponent party, you are supposed to honor them. Like, I think the professional undertaking is personally enforceable on the advocate. Because of that, you are supposed to honor your promises and not lie. For example, where it's advocates for, like, a bank, and advocates for the bank, and the advocate for the charger, and you ask for charger's documents of title, you promise in the undertaking. The completion documents will be only used for registering the charge. It will not be used for anything else, it will be not given to anyone else, you know. And then you promise that the advocate can ask for them anytime if they need them, you know, that you will transfer quickly, and then you change your mind and the advocate calls you, you don't return the documents, original title, the monies you undertake to pay the loan, you don't facilitate the payments to. So that's why PUs are personally enforceable to make sure that the advocate is liable and accountable for, you know, disappointing his promise or for being dishonest. You know, it's not a good thing to promise something when you hold the power, because once someone has trusted you and given you their original documents of title, their everything, uh, what is to say you won't go ahead and misappropriate that property or embezzle it for yourself or transfer it to someone else? You know, sometimes I also had a case where an advocate had gone away, had transferred the client's property to himself. It was shocking, but people, it has happened, and people out there, they hate advocates because they have had such happenings happen to them, you know. Excuse me. Hello? Yes? Oh, I don't I don't have credit to call her. Oh, okay, sir, let me send you. We are not friends. Like, I didn't know her prior to the order of the food that day. So, yeah, I don't know where I can find. Okay, sir, let me see. Excuse me, sorry for that. Sorry for that. It was an important one. I couldn't. So where was I? Um, yeah, I was saying the case of duties to your opponent advocates. You are not supposed to have like an attitude of an enemy. You should not play dirty. Like you should not be tricking them or double dealing them. That was held in the case of Shelley Beach Hotel versus Kenya KRA. Okay. Now, an advocate is liable to honor professional undertaking even when the same is not reduced to writing. So it's not a requirement that the undertaking must be in writing as per what this is saying, though I don't know about that. So the rules of professional conduct must honor promises in the form of undertaking. Okay. So that was duties to the next advocate to your opposite. Then duties to court. This is now the under overriding duty. An advocate has a compelling duty to court, which obligates him to not trick the court, of course, to take all points for his client, but at the same time must exercise independent judgment. So even if the people, the advocates who who was you know who were the advocates who were what do you call representing serial killers, you are supposed to have exercise your own independent judgment. What our lecturer told us is, if you know someone is, you know, has told you I killed this family, the whole family, of course you they have a right of representation, but you can exercise your own independent judgment and maybe not work extra hard, like don't go beyond and above for them. But some advocates do that. They don't care because they just say if the system, that is the prosecution, did their job well, there's no way this person will go free, no matter how much they try to exonerate him, to plead on his defense, in his defense. As long as the prosecution does its job by doing all the necessary investigations and collecting the relevant evidence required beyond a reasonable doubt, there is no cause for alarm when you are representing the villain, because the evidence will speak for itself, and the court or the jury, if it's a jury system, will understand. Okay, they will get the message as to the guilt of the accused person. So it's all about uh, challenging the system, the prosecution system. Yeah, that is what it is. Okay, so that is that. Duties to court, veracity. Yeah, so an elder should not waste public resource on points that, in his judgment, are bound to fail. You should not institute frivolous actions, vexatious proceedings, where he knows them to be useless. In addition, an advocate should ascertain veracity of information in pleadings before filing them. obligation also an advocate to be truthful to the court, not to intentionally utter any misleading statement, like when you quote, when you try to force a point, and you force some false act somewhere, not at some section, or maybe you try and force a case, to make it fit, or you mislead the court with foreign, what do you call, from maybe jurisprudence in Commonwealth. I don't know, but there's a way you can, advocates. Not everyone can become an advocate. It requires a specific mind, and that mind, if used for the right reasons, it can do so much good to the profession, to the whole justice system. But if used in the other way, it can create havoc because you know how to make things fit, and you know how to tell lies, and you know how to create this manipulation to have someone believe your case. So uh, I wish these exams are, because if I pass and become an advocate, I will be, I will just be happy to get into that atmosphere, at least on my own terms, because I really hate. Uh, it's very ironic how I came into this profession when I myself am a very creative, free spirited person. I hate laws and restrictions. I grew up free. I would just, be free and live my life. Go out when I want, come back. No one to ask me, no one to restrict me. So that is the kind of person I am. If something feels restrictive, I lash out, or I simply just leave it. I don't have any respect for rigidity of opinions of people's strict application of laws and opinions of what's right, what's wrong. I've been very flexible in that area. So I mostly operate on my own, set of principles, which which are very flexible and open, and subject to change, because I am also open to new ideas and I learn and grow every day. I would think this, but if you meet me 1 year later, I would have totally a different attitude about the same subject, and I would just as much feel as passionately about it as I did before that. uh, yeah, so it's very interesting for me, this whole experience of laws and sections and acts, and you cannot do this, penalties, fines, the whole civil procedure and criminal procedure system, filing out of time, the regulations, the rules and the orders, they have been so, it's been a very contrasting experience, with the kind of person I have been. I have been so free, and I love to be creative and to express myself, unhinged and unrestricted. I love imagination, and just to have my mind go free and philosophical on this and this. But when it comes to law, and specifically the practice of law, the practical, the procedure, the timelines, the requirements, it's been very interesting to try and submit to that set of beliefs and systems, and don't do this, you can't do this, an advocate can't do this, all those are restrictions, and rigid laws that are supposed to stop someone from fully expressing themselves. Then there's the seriousness of law and the attitude of seriousness that is everywhere in the legal profession and in schools and in the advocates training program, the dress code, all these things stifling, to be honest, for a creative person like me who thrives on free imagination and letting loose on the wheel of imagination to run to just roll free wherever it wants to go. I find myself particularly inhibited when it comes to thinking, because even in drafting and writing, the pleadings, they have rules and a set structure, something which I used to really hate. I remember in primary school, back in elementary, when we would be told to write formal letters, I detested those. I detested the requirements for formal letters. Imagine, who would have known I would be in a career that required me to draft pleadings with set instructions, pursuant to certain rules and regulations, and the requirements of procedure. It is interesting. This whole journey has been rather contradictory, okay? And I fought it. I fought with this a lot through college all the way. I used to doubt and question myself if I was in the right profession, given my personality and disposition. But here we are in doing silly exams, and you can say that I have I have a new appreciation for uh, I have a new appreciation for the law profession, because after learning all these things and seeing, the reasons why there are rules of conduct, and I appreciate that, not everything, that there are people in society who are required or who should keep things in check, who should be the advocates of the laws and serious things, and the things that are black and white, and structured, just to keep this, to make an order, for the sake of order, for the sake of structure, for the sake of uh, rule of law, or whatever you call it, order in the society for public interest. Because I'm imagining it's because of these people who keep things structured that others can afford to, endeavor in their creative pursuits, and just feel free to be whoever they want, and and express themselves however they wish through creative pursuits. If everyone in society was like that, if everyone was free and creative and unrestricted, there will be no order. A part of society needs to sacrifice to keep this society in check, and to make the laws and review them, and policies, make policies, draft legislation, all those things. Someone has got to do that, the hard stuff. And it so happens that I am one of those people now, because I am down that road anyway. I've been on that road for the last 9 years, and there's no way I could escape that, you know, unless I do some serious radical change to my career, and just dare to start afresh somewhere else, But the way I'm seeing it, I am supposed to play that part. So my creative, I try to balance between my creative and my uh, and the demands of the profession, of the rigidness. I try not to fly too high into the sky and out of this world. I try to keep a firm. I try to come back down to earth from time to time, where these laws and regulations and exist and are operating. So that is that on my commercial break monologue. Now, duties to court include not instituting frivolous suits, wasting court's time, not lying to the court or intentionally misleading the court, not to as an advocate you have to be present all facts to court, whether favorable to a case or not. Mm, mm. So the advocate is paid whether or not he wins the case. So there's no reason to go all out and above and mislead and trick and lie, just so you can get paid, because Section 46 of the Advocates Act prohibits contingency agreements, which are agreements where payment is premised on success of a case. So you are paid either way. So just don't lie for, don't mislead, as well as agreements where the fee agreed upon is less than the remuneration order, remuneration order, or more than the 25% of the general damage is recovered. However, even in discharging his obligations, an advocate should be careful not to exceed his mandate, as he is still bound by his obligations to his client and must not disclose confidential information. So we have the case of Rondell versus Worsley. The position in Kenya is that where there is a conflict between an advocate's duty to court and his duty to the client, the advocate's duty to court takes precedence. Yeah. So you can see here that it is supposed to be like that. Yeah. Yeah. Okay, so let's stop here for now, and if I get some more time, I'll try and I'll try and do some more topics in the evening. Bye.